You are here for an initial appearance after detention. The rules of criminal procedure require that you be brought before a judicial officer within 24 hours of your arrest. The purpose of the initial appearance is to have a judge list the charges against you, inform you of certain rights that you have, and to determine the conditions of your release. You should have already received a copy of these charges. The judge will review your paperwork to determine if there was probable cause to arrest you. If the judge finds probable cause, he or she will then determine if you qualify for bond and what the monetary and non-monetary conditions of your bond should be. If the judge does not have enough information to make a probable cause determination for your arrest, the state may be given additional time to amend the paperwork. You should also be aware of the following rights afforded to you by the Constitution. You are not required to say anything at this proceeding. Anything you say can be used against you. You have the right to communicate with counsel, family, or friends, and if necessary, you will be provided a reasonable means to do so. You have the right to counsel. If you have not already retained counsel and cannot afford counsel, the judge will appoint you a public defender. For the purposes of today's initial appearance proceedings, you may be able to briefly speak with a public defender regardless of whether the public defender is appointed for you. In order to have an attorney appointed by the court to represent you, you must be financially eligible, as determined by the court based on financial information you provide. Therefore, if you have not already done so, please complete, to the best of your knowledge, the financial affidavits provided by the correction officers. An application fee for the services of appointed counsel will be assessed. If you do not speak English or Spanish, please let a corrections officer know. When the judge is ready, she or he will begin calling your case by name. Please listen carefully for your name. When called, please approach the microphone as directed by the corrections officers. Thank you.
What's going on? How's everybody doing? Thanks for coming. All right. See you guys later. I'm playing. Yeah. So 1,000 subs already. It's amazing. Started a little over a month ago and never thought I'd get there this fast. But before I start, I do want to thank a few people for supporting me, helping my channel grow fairly faster than I could have done it on my own. Start with Irish Demon. He might be joining me soon. I don't know. He said he was going to come up and then he left, but we'll see. We got Time Served. I'll talk with Mike. I saw all three of them in here already. I mean, if all three of them are in here, I'm doing something right. Yep, something right. But yeah, those three. Who else do we have? Shiz gave me a nice shout out. People in Court gave me a nice shout out. Georgia Peach, of course. You know, all the suspects out there. But I want to, take a minute to say. And yeah, 1,000 subs. I promised I'd show you my face. Now you're never gonna forget it. So who wants to watch some clips? You guys want to watch some clips? Have some fun? Let's go.
And so, yeah, so off the record, we have Mr.
I should say one more thing before I start playing. These are a collection of clips, new and old. Some of them are fairly old, some of them are new. Just letting everybody know. All right, let's go.
Daryl's file?
Yes, ma'am. I'm sorry, I'm saying.
I know that we have you present. I'm just waiting for your file.
Thank you.
Is Travis Coleman back in here?
I just made the biggest mistake a man can make. I didn't say thank you to my girlfriend Heather, who is responsible for all of the artwork that I put up. I thanked everyone else but her. I'm not gonna. Yeah, I'm sorry, Heather. That was my mistake. I'm really sorry. But thank you so much for supporting me. Couldn't have done this without you.
Okay, sorry. We did call your case earlier, but you must have stepped out for a moment. So it'll be just a few more moments.
You want to know, Your Honor?
No, I have to do the jail now.
All right.
All right, we are going on the record in the matter of the city of Wyandotte versus Gregory Gerald, 231418. And appearance, counsel?
Your Honor, John Goldport, P 30758 on behalf of Mr. Durrell.
Mr. Gerald, your name, please.
Gregory Joseph Jones.
All right, and today's the date scheduled for a pretrial in this matter.
That's correct, Your Honor. And Your Honor, I've spent the last 15, 20 minutes in the breakout room with Mr. Durrell. No matter how much I speak to him, no matter how many times I explain to him what this proceeding is about, Your Honor, he consistently says he wants me to talk to you about prior involvement and that I should speak to you regarding this so that I can try to get a better plea.
Sorry, what?
So that I can get a better plea.
You should talk to myself about prior involvement.
What he says, Your Honor, and he wants to talk to you, it says he shouldn't be incarcerated. There's clearly been a breakdown. I've discussed with Mr. Durrell this whole circumstance 2 weeks ago. At that point in time, there was a plea that was offered. However, the court determined that we should not proceed at that time. I have spoken to Mr. Durrell. I've reviewed the police reports, and no matter how many times I speak to him about it today, all he says is he should not be incarcerated for these incidents. I can't get it through to him that the incident we're dealing with today, the public intoxication and the open alcohol case, are not the same charges that he claims he did 94 days on. Is that correct, Mr. Durrell?
What's going on is I actually got charged and whined out on drunk and disorderly. I got picked up by a Taylor police officer out of Taylor, Michigan. I had a beer in my possession. I got dropped off in Wyandotte, Michigan on that drunk and disorderly charge. When the charge first got picked up, I turned around, I went to the store, I bought some marijuana off of Eureka Road. I turned around, I put a nugget on the ground. And then I ended up getting a blackout that happened, and somebody drove a stolen motor vehicle, which is actually a body, which is actually inside my mind, actually operated it down in front of Walgreens and actually sat there and actually charged me with drunk and disorderly right then and there. That's how far back this goes. And I've been sitting in here and being incarcerated numerous times for the same exact charge. And I don't think that I should be charged like this at all when they actually let me drink in public that far back for 4 years in a row out there, man. That's all I'm trying to say.
Well, I'm not sure who allowed you to drink in public, or who you think allowed you to drink in public.
Yeah, but the thing is, ma'am, okay, when I blacked out, they placed me on a tether back then. You placed me on a tether. I got sent to a treatment center. I almost got shot in the side of my temple and almost killed, all kinds of shit. Excuse my language. It's been crazy living the way that I've been living. I've been in jail for 94 days. They turn around, they give me another charge. Out of Lincoln Park, a guy assaults me in the back with a pole, a 2-ton jack pole. All right. And then this is things that nobody sat there and actually the police officers haven't gave you their statements when I've actually told them. You get what I mean? And then I'm in Lincoln Park. This is 25th district. The police officer pulls up on me, arrests me, and then turns around and brings me into the Lincoln Park District Police Officer's office. The tether on my ankle gets took off. I turn around and I come in and I get told when I go in front of you that I got a unarmed robbery charge for 15 to 20 months in jail, and a drunken disorderly charge and a disorderly person. Then I get on the phone and somebody puts me on a tether saying that they're trying to review me for 2 years. A drunk tether. That's all I'm trying to say.
A drunk tether?
Yeah, an actual alcoholic tether they placed me on.
Right, not a drunk tether, it's called an alcohol
Yeah,
tether,
like,
sir.
yeah, I apologize. I apologize. I'm explaining to you what's happened out of all of these charges. And yes, I was drunk on that day. It was my birthday. I got released from the hospital, and that's what happened. Like, I heard somebody scream out in the open. I got upset. I opened up the bottle of alcohol and I drank, you know? But I don't think that I
Right,
should.
and so you have a number of public intoxication or drunken disorderly charges out of multiple jurisdictions.
Yes, but I have been,
So I
I
can see-
have
I
been
can see-
released out of cop
Excuse
cars
me.
with open.
Please stop talking, please stop talking.
Yes,
So I can
ma'am.
see why you may be confused as to why you're in custody for this one. So, counsel, you're saying that you cannot continue representing Mr. Gerald because there's been a breakdown in communication because Mr. Gerald is not understanding what you're telling him.
That's correct, Your Honor.
Well, Mr. Gerald seems to be a little bit confused with all of his cases, as he's got many of them that are of the same type of charge.
There's a Facebook fraudulence that actually goes out of my name that I've been going in and out, sleeping outside for on and off for 4 years. Somebody's been using my name out of Facebook fraudulence, using my name out of stimulus checks off of Wyandotte 930 Goddard address, and they've been using my name too as well. That I know one of you, some of you do know. That somebody.
Your Honor, I object. Facebook fraudulence. All of the objections. I win. I go home.
has been using my name.
Somebody who knows.
No, it's not.
And they've been collecting
Well-
stimulus checks and
I
that.
can
try.
all the time.
Well, if you'd like to try again, counsel, then you can try again. I just think that Mr. Gerald seems to.
What's going on, sir?
What's happening? I'm
How are you?
I'm not in the studio at the moment. My computer's down, so I'm coming to you live from the bed.
Oh, I like your name.
Yeah, it fucking suits me, doesn't it?
It does. And you know what else suits you?
What's that?
What do you mean, what's that? That's your shirt.
Oh, this one. Oh, yeah. This one was sent to me by Jude Curio.
I don't think you can hear me. This is your shirt.
Oh, that one. No, I couldn't see you. Hold on. I can see you, but you're so tiny.
I got you.
Is that
Yeah.
the one with your name on it?
It is.
Oh, that's awesome. So we're watching Judge DeSanta.
Yeah, she's yelling at a guy who's throwing Facebook fraudulence at her. So he should get off on all charges.
What was he doing?
I don't remember what he got. He public intox. I think he was on a tether. He was drinking on a tether. He
I
blacked
think I
out.
remember that guy. Is that
Yeah.
the guy that said that they allowed him to drink on the street and then they just locked him up for no reason or whatever?
Yep, that's this guy.
Yeah, I remember this guy. That was really funny.
Yep, he's about halfway through his spiel right now.
Go for it.
Be frustrated and confused because he doesn't recall which matter this is. He does recall because it was his birthday, but I think he's confusing these with other matters. So we can try to recall this matter, but I'm going to have you speak with him in just a few moments. Hopefully we can handle some of the other two. Did you already speak to Mr. Nelligan and Mr. Walters?
Right.
You already spoke to them?
No, I haven't.
Okay. All right, we'll go off the record. Mr.
Well, looks like it was more than halfway done. Yeah, that was fun. The Facebook fraudery got me. Time served. I saw your message. Stop and explain who that guy is. That's the first time I saw that guy. So if there's more to his story, I don't know it. That's just an old clip that I've had around for a while and decided to use it because it's funny. This one's also pretty funny. This guy has every excuse in the book. Let me know if he's serious or not.
I don't know what happened
What?
there.
Yeah, you just come in and leave my life all in the same day. Yay! Welcome, JL.
Oh, JL's in the side chat. He must be finished in church.
The most religious man on the internet.
The most religious man on the internet, hands down.
See, I would bring him up, but the last time the three of us were together, we didn't stop laughing and we didn't get anything accomplished.
I was actually just watching that video earlier today. I will never forget, like, jail Warren is the loudest laugh on earth. There's no question about it. Like,
The loudest and most sincere laugh on earth.
oh, unbelievable. I remember so well. We were in the porchway of jail's hotel, I think it was. Or was it your hotel?
No, we were at a gas station. I don't remember what you wanted, something, or he wanted something like a water or something. But we stopped at a gas station, and it was right across from my hotel.
That's what it was. And
you guys, I don't remember. Somebody wanted a water or something, so we stopped.
it was wasn't it the fucking madness of life video?
The madness of life.
Oh,
and right before that, we learned about all the goats being stolen. Or was it goats or sheep?
Right.
It was sheep, right?
Oh my god, I remember that so well. The fucking madness of life one, I think, was the one that absolutely killed him.
That was the one that killed him. Yes.
That was man, that was so funny. I wonder. If
all right, you ready to hear all the
know...
excuses in the world?
Oh hell yeah! I wonder if people watching right now have seen that video.
The madness of life. If they've seen your channel, they have. You've played it before.
Oh, have I? Oh yeah, you know I
think you have.
Yeah.
I think I've seen it more than once, and thought it was in jail's car.
Yeah. Oh man, that was so funny.
All right, let's count how many excuses this guy has.
And now before the court is Paul Warren of case 074157DS.
It's Paul Warren. You know what? I don't think he's related to JL though.
I was just going to say, yeah, JL's brother.
Yeah, maybe half brother. Yeah, maybe.
Mr. Warren is here today after failing to appear before this court on September 28th, 2022. For the record, that was a bench warrant hearing. Mr. Warren was previously before the court for a bond review hearing on September 16th of 2022. He was given a $100 bond, which he posted and then failed to appear for the hearing. Bond is currently set at $500. This is the 8th bench warrant. He reports no employment. Last payment made on this account was in April of 2023. Front of the court recommends that a reasonable bond be set on this matter and it be scheduled for hearing on July 19th, 2023 at 8:45 a.m. before this court.
Thank you. Mr. Warren, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing.
Thank you, Cam, better than Kardashian. I appreciate it. You loved it. Yeah, we all love DeSantis.
Oh, she's awesome.
Yeah, I was forgetting where all the buttons were.
On July 19, 2023 at 8:45 a.m. Why didn't you show up on the September 28th hearing?
I was I got in a bad health issue. I was hospitalized for a month and a half. I got shot and broke 6 ribs, tore my lung up, punctured my lung. They had me hooked to a machine for like 3 weeks trying to reduce the blood out of my lungs. Kept filling up with blood, and I just really get.
I sent you a link. Go to Discord. Just click it. You'll pop up here.
Back to health, man. I apologize. I moved from where I was living at after that because I was with my fiance. So I moved there, and it's just been kind of hectic. My father just passed, my brother just passed, my sister all just passed at the beginning of this year. I just been going through just it's not been a good year for me, Your Honor. And I totally understand. I apologize. I got a job right now. I've been working for the last year and a half, so I've been paying child support every week. It's been getting took out of my check. So I know I've been paying. I apologize for not showing up. It's not that I was, trying to ditch you guys or nothing like that. I'm sorry. I apologize. Just been going through a lot,
Thank you.
Mr. Chapman, has it been paid through income withholding?
Up until April, the last payment in April, there was income withholding in place.
Okay.
Yep, I just lost my job like a couple months.
You should be able to. You can disable the camera. You don't have to have a camera. At least I think that's how it works, right, Demon? You don't have to have a camera.
Yeah, you can disable the camera, unless what she means is that she needs cam access on her browser. Because some
maybe.
browsers have cam access turned off, so if it's Google Chrome, you have to go up into settings and turn cam access on.
I don't know.
I think that's maybe what she means.
I don't know. Sorry, without seeing what error you're getting, Peach, I don't know.
Yeah.
But yeah, maybe try a different browser. If Demon's right, then a different browser might work.
Yeah, I think that's what it is anyway. Oh,
was
people in
back
court, good to see you.
When my father got killed, it kind of put me in a forensic, man. I've been seeking psychological help, and I've been trying to keep my mom above, but I totally understand. I got a job right now. I'm working.
There you go.
I have no reasons not to come back to court. I promise I'll be here at my next court date. I don't want any issues. So I definitely, it's not that it's a lot. I'm sorry. I apologize. Just coming as a man.
Well, what I'm going to do is I am going to reduce your bond in hopes that you'd be able to be released. I'm going to set your bond in the amount of $250. If you're able to post that, you'd be able to be released. Do you have any questions?
Yeah, my girlfriend actually have $150. She got that right now. That'd be all I can come up with for to my next paycheck within 2 weeks. So if you could do 150, I can post that today with no problem. And I definitely will. That's just all I have. And I want to give you something,
Okay. Mr. Chapman, do you
Wants to
have
give
any
you something.
opposition to the reduced
Kind of reminds me of
amount?
an episode of Pawn Stars.
I do not, Your Honor.
We'll change it to $150. I will tell you, Mr. Warren, if you don't show up on the 19th this time, they pick you up again. You're not getting out of jail. You understand?
I understand, Your Honor, and
Okay.
I greatly appreciate that.
Okay.
I've got a friend who's an expert in bonds. Let me get him down here. I can do like 150.
He came out with, I don't know, a dozen excuses, and then he not only got out, he successfully talked down the judge's bond.
Yeah, that's actually really impressive. He got shot. His dad
I've got
got
150.
shot.
Take it.
He's like, take
his
it.
dad, his
Your Honor,
uncle, his sister.
I love that.
I think we were talking when he said this, but he said, I've been paying my child support. I've been working for the last year and a half. They're taking it out of my check. And then the judge said, well, you haven't paid since April. Well, I haven't worked since April. So he hasn't worked for the last year and a half.
Oh, for fuck's sake. Oh, man. I can't believe he managed to actually talk. Like, 250 was already a good number anyway. 150, and to be able to actually talk him down to 150 is actually quite impressive.
Yeah. It worked. I was sitting there laughing, and then when the judge yeah, you can go 150, yeah, that's fine.
And not to mention that the 150 is coming from his girlfriend, not him. That's a master play right there, to be fair. It's not only is he talking down to 150, but he's getting somebody else to pay it as well.
But you know what? He lost his whole family, so it's the least his girlfriend can do, right?
Yeah, exactly. That's
all right. This next one's from Bond Court. I've got, I think, two clips from Bond Court. The intro is from Bond Court. Did you see it? Were you watching at that time?
Yeah, I was listening. I was actually listening while it was playing. That's what they read out. It's is that a recording that they play?
Yeah, it's a video. They play it right before all the giant arraignments, the arraignment mills, I like to call them. Where they have 100 people that they just roll through. But yeah, they play it. But I loved it. It reminded me of something I saw in elementary school when they roll the TV down on the cart and they put the VHS in. That's what it reminded me of. The music. I was laughing when I was watching it.
And you're like the coolest person in the class if you get to go get the TV.
Yep, you were. Yes,
You go on a
absolutely.
mission.
Or if you got to go hit the play button.
Oh my God, that was God tier.
Earlier, right?
Oh, this woman.
Was that
This woman.
open Ohio warrant?
Oh, it's not extraditable.
Okay,
So
all right.
it's not
All right.
Okay.
going to be extradited.
All right, ma'am, your name?
Hi, my name is Ala Kotler.
All right. 2022
And Your
MM2.
Honor, there is a PC argument just for the court's information.
Yeah, I'm on the fence about it, so I'll hear argument. 2022 MM21980. One count.
You got a
of
fan, Demon.
Trespassing on property after warning. One count of
People in
misuse.
court, if
911.
that's the
Let's,
channel, people in court,
let's hear the
they got a
PC
fan
argument.
too. I love that channel.
Your Honor, defense would be arguing that there's
It
no
is.
probable cause to the misuse
Oh,
of
awesome.
911. The misuse of 911 requires an element of knowledge. It seems like whether, reasonable or not, at the time, she was not in the state of mind to realize exactly what was happening. It seems like she was under the impression that she did need the help and use of 911. And for those reasons, we would argue that there's no probable cause.
That's a good
Never
argument.
Just allege that the knowledge was the uniformed police
This
officer.
defense attorney is pretty good. For seeing as many people as she does, she's
in a
good.
department issued
Like
uniform
that's a great defense to that charge.
with the words
because
police, the patch with OPD.
if you can just
um,
talk away
there should be
the
some
intent
inferred
portion
knowledge
of it,
given that
you're sitting
he
pretty.
was not undercover.
But just wait.
In his full uniform.
Just the way it's phrased that she proceeded to call 911. That was my reading. That I don't know. Did she
Can you
actually
just
call
start
911?
Touche's
Yes, I do.
most
Well,
recent
don't
comment? I
talk
got a
about
really
anything,
funny
please.
story about that. Do you want me to tell you now?
Yeah, go ahead. You said start.
All right,
You got a funny
so-
story.
So I went to school in like a brand new high school, and we didn't have in the high school we didn't have VHS tapes or any of that stuff. We had those interactive whiteboards. They're like big computer screens, and basically once the teacher would leave the room, one of my friends, I would never do such a thing, would immediately run up and turn on Pornhub and like lock the screen, so it would be stuck on widescreen, full fucking speakers, surround sound. Yeah, it was pretty brutal. And like lock the screen, so it would be stuck on widescreen, full speakers.
Look who's here.
That was pretty brutal.
Oh,
Like, lock the
is that me?
so it would be stuck on widescreen.
It's yours and Demons.
So,
Look who's here.
That's me. Yay.
So, I have a couple videos, and then I have Demon on my first. Actually, below
Okay.
it. So I don't know how long
Say
you've
that
been
again?
there. So you might have been there for a while. The whole time you guys were trying to figure out what was going on, you were just on the second row, and I didn't realize it.
Hey, it's fine. I'm here. That's all that matters.
Yeah, welcome.
oh, is that Peach?
That's Georgia P.
Oh, hey, good to see you.
Hey,
Well, not see
babe.
ya, but hear you. How are you?
I'm good. I'm very
Good.
good, love.
That's brilliant.
Peach has the premiere at 8:30. Is it 8:30?
It is 8:30. Thank you for knowing.
Yeah, you're welcome.
I have a video going out. I think it's at 1 a.m. my time, which is in about a half an hour. But it's not a premiere or anything, so
Well, ours is only Von Kerman is my partner in crime. Ours is 37 minutes, so it should be perfection.
I completely agree. People in court completely agree.
yeah, me too.
All right. Well, if we have an hour, I've got about an hour left. So
Let's do this.
Oh, well then,
Let's
well,
do this.
That's okay.
I'll dip for 2 minutes. I'll push my one out to 1:30 my time,
Oh, you're so very sweet, babe.
because that way then people can jump over there afterwards. Give me 2 minutes. I'll be
Exactly.
right back.
I love it.
Demon, I also know that it's really late your time. Don't feel obligated you have to stay on. So whenever you got a dip, just dip.
Your Honor, there's also competency
a rightful-
concerns.
Obviously.
Thank you.
I was under that.
No, don't, please don't say anything. It's okay.
We're not.
I know.
No, you-
I
I have a bachelor's degree. I'm
I
an
understand.
educated
Listen,
woman.
ma'am, today's just your first appearance. We're going by what's written on the paper. What you say here today is not going to change what's written on the paper. Instead,
No,
what
I'm
you-
not
listen,
trying to change it. I just
listen.
want to tell my story.
Well, listen, today's not the day to do that. Anything you say, Keenan, will be used against you. Today's not the day to talk about what actually happened. We're just going by what's on the paper. So anything you say, Keenan, will be used against you. You have the right to remain silent at your first appearance. It's usually a very good idea to exercise that right. You'll have the opportunity to tell this somewhere down the road.
I was
but-
very offended by the lawyer who said I wasn't in the right state of mind.
Okay,
'Cause I am.
all right, well, that's her job. So,
She didn't even speak with me 1 second. Not 1 second did she speak with me before the court.
all right, ma'am, I'm gonna ask that you just hold on 1 second, okay? I'm gonna find probable causes to count 1 and count 2. I'm gonna stay the bonds at count 1 at 500, set bond on count.
I'm homeless. I'm homeless. I do not have a car. I do not have a home. I cannot pay any bond.
Well, you have an attorney?
I am
Listen,
homeless. I am
Okay.
homeless.
all right, if that was criteria for getting out of jail, then that's all anyone had to say. It's not gonna happen here
It's
today.
not what I have to say.
What's-
It's a fact.
What's gonna happen is you made
It was
the,
at a shelter.
all right,
That's where
your
I
bonds
was
are set.
warned.
The PD's appointed. Good luck to you, ma'am.
And Your Honor, the bonds quickly, I apologize. I missed them.
Yes, Your Honor.
Hold on, why
Thank
did they
you,
bring her to
Ms.
custody?
Costello.
She has a bachelor's degree.
Right? It's because she's homeless. She didn't have anywhere to go, so they just let her stay there for the night.
Well,
No, free
probably
lodging.
not then.
Free lodging. Yeah, this one's more serious. This one isn't as funny. This guy's pretty bad, but I love this judge, so I just decided to keep it in.
Let's do it.
Thank you, Your Honor. The state will be seeking bail in the amount of $100,000. That's based on several factors. Number one, the large amount of controlled substances that was found in the defendant's vehicle as he passed through our county. He obviously has no contacts or ties with our community. He was simply taking these drugs back to, looks like Iowa, which is where he's from. He does score an 11 on the NPRA, and that's
Is
in addition to
Iowa
that, he
really
has
a
that
state?
extraditable warrant out of Iowa for what appears to be a felony possession.
All right, hold on. I'm just under the impression that everyone knows who Demon is. Yeah, Irish Demon has his own channel.
Oh my God, Irish Demon is. He's large.
I'm not that fat. Jesus.
I mean, what most people don't know about Demon is he's not actually Irish. He actually lives in Florida. He just got really good at the
Yeah.
accent. He's never been to Ireland.
Apparently, I live in, according to one person, according to one auditor, I live in Florida. According to Chile, I live in both Australia and not Pennsylvania, Cincinnati. Somehow that's possible. I don't know how that is even remotely possible. And then another guy was back in the Flat Earth days, was looking around somewhere, some town in Washington anyway, because I convinced him that I lived in the same town as him, that I was an Irish immigrant in his town, and he was absolutely convinced that that was the case. And he was like, well, if you live here, then tell me what's across the way from whatever 7-Eleven. And I just instantly Googled it. I was like, oh yeah, that's that old pizza place. What? You do live here? I was like, you fucking idiot. I love it. You know who that was? That was that guy, without a doubt, one of my proudest troll moments in the history of my YouTube career. Daniel Pratt was his name. Still is. And I sent him a card. And when he opened the card live on the air, there was like a pop-out dick. Have you seen that video?
No, I have not seen that video.
Oh, no way. It's in my shorts. Not the pop-out dick, the video. But,
I mean,
yeah,
that's generally where most men's dicks are.
like, he
They're in their
opened it
shorts.
live on the screen, and it just went right into his face.
In
Oh,
the
it was
shorts,
beautiful.
Colin.
In the
It
shorts.
Most men's
literally-
dicks
it
are in
couldn't have
the
been better.
That's generally where they're kept.
Okay.
I'll look for it. But yeah, I don't know if he actually said his channel is Irish Demon. That actually is the name of your channel, right? It's
It
nothing
is,
else,
yeah,
it's Irish
yeah.
Demon. I've been there for so long, I don't even remember. That's just your name. But yeah, Irish Demon, simple. He has a picture. This is his symbol.
That's it.
Irish Demon has a fabulous channel.
Thank you so much.
He does. He does. Can one of my mods post the link?
I'm gonna do it right now.
All right. Thank you.
You're welcome.
All right. Let's watch this drug trafficker. Just listen to. Nothing exciting happens. Just all the charges and everything that he's done is just like, wow. How does one person have this much time?
Of a controlled substance, third offense or more. His criminal history is quite lengthy. It does start, or the recent criminal history is from Iowa. He has a 2022 possession of a controlled substance. The criminal history is pretty confusing out of Iowa to read, but it says second offense. It's unclear if it's a misdemeanor or a felony. And then in 2021, he has a possession of a controlled substance, methamphetamine, and unlawful substance tax stamp convictions. It appears that they're felonies. He was on a suspended sentence, prison time. So I'm assuming
that's also out of Iowa.
Yes, out of Iowa.
Well, then, wouldn't it make sense, or can't I conclude that a second offense for possession is also going to at least be a felony, not a misdemeanor?
Yes, I believe so. I believe so.
I think that's a reasonable conclusion. Yeah.
Yes, and then he also has a third offense from 2021 as well on his history. Then back to 2013, he actually has a federal counterfeiting conviction, which he was on prison and pretrial or post-trial, as they do it in the federal system, released. He was revoked 2 different times in 2015 and 2017, and then he was sent to prison in 2017 for 18 months for that federal conviction. In 2009, and it doesn't say exactly where that's out of. I think it's Iowa as well, or Ohio. 2009, he has possession of a controlled substance felony out of California. 2003, make or pass a fictitious check felony, carrying a concealed dirk or dagger felony, both out of Fullerton, California. In 2001, in 1998, 1999, and 2001, he has violations of parole, all out of California. He's got a 1996 evading felony, a taking a vehicle without consent felony, and a robbery second-degree felony, all out of California. And his history goes on and on. Back till 1984 was his first conviction out of California, and it was for a burglary second-degree misdemeanor. He does have a grand theft of a vehicle in 1991, which was accompanied by a prison escape felony conviction without force. So again, this defendant has been committing crime for literal decades, and now he's in our community possessing large amounts of methamphetamine. So based on all of those factors, we do believe the $100,000 is appropriate. He obviously has that extraditable warrant that's holding him as well, and we would like him to stay here and take care of these charges if possible first before being extradited.
No, I mean,
so how would you defend that? You're his defense attorney. What would you do?
I'm just trying to figure out, where did he get the time to do all that? Little known fact, he was one of the guys being crucified at the same time as Jesus for robbing.
Was he on the left or the right?
He was on the right.
Oh, he was the guy on the right. Okay.
Yeah, the guy on the left was cool, man. He didn't do shit. He just got wrapped up in the wrong stuff. But
kind of like the guy in the middle.
Well, like, where did he? Yeah, no, he definitely didn't do anything. They just had it out for him. Well, like, obviously he's a recidivist. He's obviously going to do shit again.
Yeah.
Like, you can't exactly turn around to any reasonable court and say, I've changed my ways. You haven't changed your ways since the mid-'80s, motherfucker. You're not changing now, are you? That's
He was
unreal.
cranking his car the first time he was moving drugs.
He what?
He was cranking his car the first time he was moving drugs.
Back when it had, like, leaded petrol.
Exactly.
Or coal or some shit.
All right, well, let's
was
see
he
how the
involved
defense...
in, like, old railway heists and shit.
Horseback, yeah.
Yeah, theft of a pony.
Yep. He had drugs on the horse too.
Category A or Category B, so no cash discount.
Well, the problem with the administrative order, it does say category B, but it's specific as to victim, firearm, or residential burglary. So unfortunately, these charges don't fit that. You certainly have the discretion to make it no 10%, which the state would certainly ask for.
Okay, thank you, Mr. Hinman.
Thank you, Your Honor. I would just mention that Mr. Hoffman is unemployed. He receives government disability.
This
He
is
gets his
employed
medical
already.
health
He's employed with
benefits
the fucking
from the
drug dealer.
government. Beyond that, this is a number that's way out of his reach. I would ask that bail be set at $50,000 bondable.
I'm not gonna be able to do that, Mr. Hoffman. Once again, your criminal history precedes you. It's horrendous. You scored an 11 on the NPRA, which is very,
Horrendous.
very high. You're for all kinds of reasons I can mention, you're a flight risk in my concern, most notably because of your lack of ties to our community. You also are an extreme danger to this community based not just upon your trafficking in drugs allegations, but all your criminal history and other factors. So I do find there's clear convincing evidence of both, that you're a danger to the community and a flight risk. I think that a high monetary bail is necessary in this case to maintain the safety of the community and that you appear for this court. I'm going to assess it at $80,000 bondable or $80,000 cash. No cash discount. I am using my discretion. I am going along with Ms. Cosso's request. And I do find that our 10% is not warranted in a case like this for you, Mr. Hopkins. So it'll be with $80,000 bondable or $80,000 cash. You can always go through a bondsman. And it comes with conditions of no drugs, no alcohol, no possession or consumption of either. Check-ins with DAS at least weekly and random testing for any evidence of same. Any other conditions requested, Ms. Cosso?
No, Your Honor.
All right, his next court date will be a 72-hour for the 28th of July at 9 o'clock. Hopefully we have a complaint by then. We'll see everyone then. Thank you.
You know what his biggest mistake
Did
here
you get
was?
that date?
His biggest mistake was not hiring the guy from a couple of videos ago to get his bond down to 150 bucks and then get his girlfriend to pay it.
He didn't say that everyone in his family died. And
Yeah,
he got,
no, just tell him everyone in my family died. My girlfriend's got 150 bucks, take it or leave it.
I
And
got
just
shot.
Fucking okay.
I've had a job for a year and a half.
Yeah, selling drugs. Oh man, that's fucking unreal.
I'm a taxpayer. Let me back into the community. I'll help you fix the streets.
Oh, absolutely. Oh man, that's fucking unreal. Right, I got to bounce.
Do you mind
because it's getting super late here, and I got to be up early again. Fucking the last time I was babysitting this one particular kid, to be fair, like the nicest kid ever, but has worse ADHD than me, which is saying something. And he woke me up with an ice pop to the head at 6 o'clock in the morning, demanding I open it. So yeah, I told him next time he'd be getting an ice pop right back at him. So
Well, that's a good way to wake up.
Oh man, no, it's not. It sucks, especially after only 2 hours sleep, just getting bam, ice pop to the face. Fucking brutal. But anyway, yeah, no, I gotta go get some sleep. But it'll be my birthday soon.
It's sometime this week, right?
I think it's next Tuesday or Wednesday. Next Tuesday or Wednesday. But I was hoping to do a big live stream if you want to come along and have I guess we'll have to invite JL Warren. It wouldn't be fair. Oh, maybe we could play that video then. That'd be fun.
That would be good. Yeah, let's do it.
You know what? For anybody watching right now, I'm gonna play these videos on my birthday live stream because they are fucking hilarious. Check this out, right? Oh shit, what was the name of that? I'm trying to remember what the name of the frog was. Damn it. It's a type of frog. It's a frog in the Amazon that can't jump. And it just yeets itself. I swear to God, I sat here at 9 o'clock this morning, absolutely howling, laughing at this fucking frog. But check it out, right? Just watch that. I'm going to be playing them on my live stream next week. Oh my God, man. Just thinking about it right now is making me relapse. I know it sounds like a really silly thing, but trust me, watch just this frog just yeeting himself. It's hilarious. It's a whole species that just eat themselves. But anyway, but yeah, you're more than welcome to come along. It'll be, I think probably next Tuesday or Wednesday. No, it'll be next Tuesday for sure.
Okay.
Because I'm away next Wednesday. But yeah, we'll get in touch before then anyway.
All right, sounds good, man. I appreciate you coming
so
up.
much, and congratulations on the 1,000.
Thank you. Thank you.
All right, man. Go on, I'll talk to you soon.
Yeah.
Take care, buddy.
All right, have a good night.
See you guys. Bye-bye.
Yep, you too. All right, and then there was one. If anyone else wants to come up, just let me know. I'll get you a link.
Reading that date one more time.
Oh, Friday the 28th, July 28th, 2023 at 9 o'clock. Are they still for 9 o'clock?
Yes.
Yeah, 9 o'clock. They never start till after 10. Okay, 9 o'clock. Next case.
Richard Charles Irwin.
Mr. Irwin,
9 to 6.
Who gonna co-sign?
I'm assuming she is, but I.
All right, now that the serious is over, we're back to the funny. I tried to rotate serious, funny, serious, funny, serious, funny. So, but yeah, this is good. This is funny. It goes over the whole docket though. So, and I don't even think I recorded this guy's case because that's not what's funny. It's everything that happens after it, and this goes on for about an hour. Just you'll see.
I don't know. We can't. Is Ms. McLeod? If the mother, we prefer for the mother to not co-sign. Does he have another person?
He has a 24-year-old sister who lives in the household as well.
I think she has to be 25. Is that correct, Mr. Howard?
Instead of just giving you a thumbs up, yeah, I saw it. I was there. He's going to do his fundraiser next weekend, I think he said to me. I was trying to work around him because I was worried that he was going to do that today. And I didn't want to overlap because I wanted to be there for him. So, yeah, I think he said next weekend. I
mean, if you want her to do it, that's fine.
All right. Well, what's his sister's name?
I am not sure, Your Honor, but I can ask him.
Please ask your client.
He's here Maxwell.
Can you spell that?
I don't know how to spell her name. I ain't gonna lie.
You can't spell your sister's name?
No.
All right.
Okay.
Miss Maxwell, were you able to unmute? Are you able to put in the chat, Mr. Maxwell, how to spell your daughter's name? That will help us.
I believe she's left to try to rejoin, Judge.
Yeah, I believe that's what's happened as well. Happy Saturday. We really are. I'm going to give her about 5 minutes. We may have to come back to this just to get the information for pretrial. Okay, she's coming back.
Maybe not.
Miss Maxwell, if you can't unmute, can you just type the name of your daughter into the chat feature, please, so that pretrial can have the information?
Alternatively, Your Honor, I could call Mom because I did speak with her earlier and get the information from her.
All right, that'll be
once
fine.
I'm finished.
All right, thank you, Ms. McLeod. We're going to move on to
Hold
the
on,
next.
put it in the chat.
Okay. All right. So that concludes this case. Mr. Dudley, please learn how to spell your sister's name. That's a critical of importance. All right. Best of luck to you. Who do we have next?
So hold on. This is Peter. I got 3,000 pretrial, no further violence.
He needs to take the one day anger. We're in this curfew, 9 to 6, 20 hours.
My client has very limited, Your Honor, criminal history. He is gainfully employed. We'd like for him to get back to his employment at this time. He does live with his brother, so he does have community support within Georgia. He's been here for 3 years now, and then in the past he'd been here 3 years prior. Your Honor, we feel that this is a situation he does not know the person, the alleged victim in this matter. There was somewhat of a disagreement at the at the incident location, which is a Popeyes. He definitely wants to definitely defend his innocence. He does not feel that the facts portray anything near what actually happened that day, Your Honor. We believe a signature bond would be appropriate in this situation due to the fact that he does not have any violent criminal history, definitely not here in Georgia as well. So signature bond, Your Honor.
Now, does he have to access the Popeyes at all to get to work?
No, he does not, Your Honor. No further contact. Stay away from the incident location. I think would be, he has no problem with that. Like I said, he does not even know the person who worked at the incident location and who is the alleged victim. Your Honor, we feel that he can definitely adhere to those conditions. So a signature bond we feel would be appropriate due to his limited criminal history, very limited.
All right, defendant will receive $1,000 surety bond. He is to have no contact with the alleged victim, stay away from that Popeyes location, and have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing from the state, Your Honor.
All right, best of luck to you, Mr. Bloxton. Ms. McLeod, I saw you came back on. Is there a concern?
Yes, Your Honor, there is. The sister of my client was unable to sign, but I did speak to his grandmother. Her name is Sheila Dudley, and she assures me that she will sign on her grandson's bond, Your Honor. So I had to come back on to let the court know that.
Okay, so we would have to change the name on that waiver, Mr. Howard. Ms. McLeod, will you put that name into the chat for us?
Yes, Your Honor, I will.
Thank you.
I had a question. Did she go to try to sign or she just came?
No,
Okay, I just making sure.
she's indicated that she had to go to work and she wasn't able to come to sign.
Okay. I didn't know if she had went and they told her no or something.
No.
I just sent them the waiver. So okay, thank you.
And also, I'm going to need where exactly they're supposed to go. I'm not sure where pretrial.
I'll put it in the chat for you.
Please do. Thank you.
All right, I'm not surprised that we've had that. All right, thank you. You're free to go. And
I'm
sorry. What was the breakdown for this bond? It's
$2,500 on each count.
Yeah, 25, whatever it already was. I didn't change the bond.
Okay, thank you.
And what was the reset date again, Your Honor?
August the 3rd.
Okay.
Your Honor, I need to let the court know something.
Are you back again, Mr.
I have your
Trying to go home.
Grandma can't make it.
You do not want to have a good weekend, Ms. McLeod. Go ahead. What was that?
Grandma can't make it, Your Honor. So Uncle, and I can put his name in the chat to be doing it.
You know what? No, he's going to be required to prove he can spell all of his relatives' names.
And he would have difficulty with his uncle's name is Ozzaer.
Mr. Howard is not going to be pleased. Mr. Howard, they're asking you to again change the person whose name is on this waiver. Grandma can't make it.
This is Uncle?
Ozzaer Maxwell. I put it in the chat.
Okay, and Ms. McLeod, we're at the end, so you won't be able to come back if Uncle can't make it.
That's what I'm thinking. So I'm hoping that Uncle can. I spoke to Grandma, spoke to all of them.
Or the uncle will have to pick up Grandma because that will be it. Okay, we're gonna change that. What happened to position 11 and 12?
Next, I have.
Hi.
Well,
Can you hear me?
hello. I can hear you. Can you hear me?
I can hear you. I have absolutely nothing to add. I just wanted to come say hi.
Everybody, this is the one and only Heather.
I just wanted to come say cheers.
My better 2/3. Cheers.
More like the better 90%.
I mean, I forgot to say thank you to you.
You're still in the doghouse, by the way.
Just so you know, she texted me like the second after I finished saying thank you to everybody. My phone just starts going off. I'm like, oh no.
Yeah, I heard the ding on your actual stream, and I was like, if he doesn't look at his phone, I'm gonna kill him.
But you are more than
hey,
welcome.
Everybody.
Oh, there you go. Say something.
I am saying something. I wanted to come on and just say thank you for everyone supporting Colin. I can't believe you have this many subs in a month. Both of us didn't think that you were going to get this far, so I just wanted to come on and cheers you. And yeah.
Neither one of us had any faith in me.
Hey, that's not true. I pushed you really hard to do this. I've been telling you for the last year, make your YouTube channel, make your YouTube channel. And look where you are just a month in.
All right. You want to watch some videos?
But I know nothing about court stuff. This is all new to me, so I have nothing to add. So I'm going to leave. I just wanted to come on and say hi and say congratulations.
All right. Well, thank you. Thank you for showing your face. If I have to show mine, you can show yours too.
Moral support. Okay. Bye.
Bye.
Of 110 Properties v. Teresa Nguyen. This is 23-2005708. I have Mr. McCreary and Mr. Kiernan.
Yeah, sure.
Thank you. I did have an opportunity to read the file and the materials and affidavits that were set forth in that. Mr. McCreary, it's your motion.
Thank you, Your Honor. This originally came on as an unlawful detainer for the non-payment of rent. We went through the ERPP process. We had a mediation. You know, we were looking at potentially with 1/3 of the monthly rental payment, a 4-year payment plan and so forth. We came up with an agreement, and that agreement allowed Ms. Nguyen to pay down her balance and have a lower monthly payment. And we were only into it a little bit when she failed to make the monthly payment that we agreed to. And so now we're just guesstimate around $3,000 in rent owing. And the agreement is Exhibit C to my client's declaration in this matter. And on page 2 of 5, it says, we agree that if the tenant defaults on any rent owed under a repayment plan, the landlord may proceed with an unlawful detainer action as set forth in RCW 5912-0303, but subject to any requirements under the eviction resolution pilot program established on.
I was paying so much attention to chat, I forgot to pause it. This is one of my favorite things, is when two attorneys go at it. Again, not the most exciting case for people like Heather, who doesn't really understand what's going on. But the attorneys go back and forth at each other, and it's very eventful to me. So I put it in, so you guys can watch it with me.
Under 5918-660. Our view of this is that this is essentially operation of law. It's the agreement that was entered. She failed to pay, and that should result in an unlawful detainer, a order for writ of restitution being issued. The excuse that's given in this case is that she was overpaid by Social Security and whatnot. Being overpaid shouldn't be an excuse for failing to pay rent. And I understand that the failure to pay issue is that she was paid too much over a period of time, and then they just shorted her a check. Communication would have been key on that. My client wasn't made aware until late, but I think everybody on this docket is aware that you can go to just about any church in town and get an emergency $700 or whatever is needed to get yourself out of these situations. The problem with Ms. Nguyen is we have this long-term track record of these kind of problems. She even says that she withheld the rent previously that led up to this case, knowing that she wasn't supposed to do so. So I guess I feel like this one should just be an automatic. You know, we had an agreement. She didn't meet the agreement. We're requesting our order. Thank you.
Mr. McCreary, you referenced your client's declaration. Can you tell me when that was filed?
Front page of it, there's exhibits there. That was with the motion and declaration, June 7th. Declaration of Eric Smith. This one has been put over a couple times because Jill Carmy felt like her experience in the area of benefits law might skew her view of the issue, with Ms. Wynn's benefits being overpaid over time and so forth.
Okay, thank you. You'd referenced your client's declaration. I was worried that there was a separate declaration other than what was attached to the motion to show cause.
No,
So,
just the combined motion and declaration.
very good. Thank you. I do have that and have reviewed it. All right, Mr. Kiernan.
Okay. I would agree with Mr. McCreary that this would be a straightforward case if federal housing laws didn't apply. This is we were asked, when Miss Wynn found out that she was receiving a Social Security overpayment, she went to her landlord and asked her if they could make a reasonable accommodation to try and work with her. At that point, rather than entering into an interactive, collaborative process as the Fair Housing Act statute requires, they simply said no. Now, Miss Wynn's ability to pay or inability to pay was directly related to the fact that she was on Social Security disability. Now, it has long been held that, for a reasonable accommodation for a person that is on Social Security disability, if they get their check on, like, say, the 6th and rent is due on the 1st, there's a reasonable accommodation that they can make a payment on the 6th because of their disability. So when Miss Wynn made that request, showed them that for 1 month she would not be able to make one $600 payment. However, she would be able to make the payment the next month. The landlord was obligated under the Fair Housing Act to make a reasonable accommodation, which would allow her to use the full use and enjoyment of the property. And I granted this is kind of a unique issue because payment plans aren't real, haven't been around for a very long time, and there may not be an issue on point for this issue. But the fact of the matter is, the reasonable accommodation that Miss Wynn asked for when she showed them would have cost the landlord almost next to nothing. Miss Wynn's rent is $800 a month, and rather than waiting 1 month for that $800 and adding simply 1 month to the end of the payment plan, the landlord decided to spend more money on going straight to the unlawful detainer process. So by failing to do the reasonable accommodation here, the landlord actually ended up spending more money than they would have required. Now, Miss Wynn's rent, with the combination of her rent and her back pay, was only $800 a month. This is not an undue hardship on the landlord to simply forego 1 month and add it to the end of the payment period. Very unique issue because the landlord had full knowledge that this issue would not repeat itself and was a one-time only issue that was directly related to her disability. Miss Wynn is unable to work. She's on a fixed income. She cannot control when and where she gets paid as a direct result of her disability. She asked her landlord for a reasonable accommodation for the full use and enjoyment of that property, of simply putting off rent 1 month and adding it to the end of the payment period for a total cost of the landlord of $800. Now, she wasn't asking not to forego rent. She was simply asking to delay the start of the payment period 1 month. I guess the total cost could have been $800 or 10% interest on $800 over 3 years. So there might have been a small cost to the landlord here. But to say that there's an undue expense, there simply is not. Where, this is $800 over 1 month directly related to the disability. They were required to enter into a collaborative process under the Fair Housing Act, Your Honor. They failed to do that here. And rather than entering into a negotiation, they simply said no and decided to evict over $800, Your Honor.
Okay, Mr. Kiernan. Oh, in a moment, Mr. Kiernan. You say that the landlord didn't enter into a collaborative process, but didn't they already enter into a collaborative process to set up the repayment plan?
But that wasn't as a result of a disability in the fair housing. So certainly, and I'm not saying the landlord didn't enter into a process here, the ERPP process, which is required of them by law under the statute.
But wasn't your client disabled when she engaged in that process?
Absolutely, but they weren't. She wasn't asking for a reasonable accommodation to get on a payment plan. She was asking for a modification to the payment plan for information that she had no idea about when she entered into the payment plan. I don't know how familiar Your Honor is with Social Security disability benefits. There's not really a whole lot of information that someone can have for a non-payment, because it can be just a small amount for a few months. There's just really not a whole lot of knowledge that she could have had that this was possibly coming. If she would have known that it was coming, could she have negotiated a different payment plan? Maybe. But with Social Security, you get a notice. If you dispute it, you can keep the same amount and go through the process, but the client was unrepresented by counsel. She probably did not know that, so she just took it at face value. So there was no possible way that she could have known that she was going to be having this overpayment and unable to make that payment when she entered into the payment plan. So the reasonable accommodation that I am saying that they failed to make was after my client breached the payment plan. We are not disputing that my client breached the payment plan. But what we are saying is that the reason for her breach was a direct result of her disability, and the landlord should have accommodated that because it wouldn't have created an undue burden for them or created any real administrative costs for them at that point. This was before they filed the unlawful detainer, and when she took her Social Security disability paperwork to them and was like, hey, for 1 month, I will be unable to pay a full month's rent. I will, as you can see in this paper, I will be able to make that payment next month and every month subsequent. There's just 1 month that as a direct result of my disability, I will not be able to do this. This is a very specific circumstance that is unlikely to occur again. But I think my client has sufficient documentation of this issue. It's reasonable that she did not know that this was going to occur, and the landlord should have just worked with him. So I believe when my client received this paperwork of the overpayment and went down to the office and spoke with the landlord, that is when they were in the obligation to engage in a collaborative process.
Okay, I understand your argument.
Okay.
All right, go ahead, Mr. McCreary.
Thank you, Your Honor. There seems to be two people reading a crystal ball here. Counsel statements that the landlord knew it would only be 1 month. I'm not sure.
All right. So I saw a couple things in the chat. So what I think happened is I think when she first started getting disability, I don't think it just happened where she was getting it and then it multiplied by however much. I think it started as too much. So then all of a sudden it just dropped because they were taking back what the overpayment was, so she couldn't pay rent. I think that's what happened. Went to the landlord and tried to tell them, but this was after she already didn't pay rent for a while. And so she was already on a payment plan to pay back the back rent, and she asked for another month. I believe that's what they're arguing. If you guys saw something different, let me know. But that's what I think is going on.
Sure how counsel gets to project what my client can be certain of into the future regarding Ms. Wynn's payment.
It's in the document.
Well, hold on, one at a time.
If anything, my client's knowledge of Ms. Wynn's payment would suggest their look into the crystal ball is more accurate, that Ms. Wynn isn't going to make payments, that she's going to fail to pay, and that she chose unilaterally to not pay, which led to this whole situation. So the reassurance that she's going to pay isn't terribly meaningful, and for Ms. Wynn to assert that somehow it's a no-brainer for the landlord, they'll just get paid next month. Well, that hasn't happened over and over again. But I think the bigger issue, and I think the issue the court identifies in questioning counsel, is that really this isn't a reasonable accommodation situation. I mean, to the extent that we went through all of the IRP process and did all of that, that's tremendous amounts of accommodation and bending over backwards by my client. But if you break down what the basis is for the non-payment, it's her financial irresponsibility, which has nothing to do with her disability. This isn't, my leg didn't work that month because of my medical condition, therefore I couldn't earn a paycheck. She received more money than she was entitled to, and financially did not maintain her responsibility, and that's not her disability. I don't have to see her paperwork to know that financial irresponsibility isn't her disability. So she entered into the agreement, and She failed to pay under the agreement. There's no accommodation we can make ongoing for that doesn't just completely ignore our rights. And her claim isn't based on a disability. It's based on her financial irresponsibility.
May I respond, Your Honor?
Well, let me ask a question. Did she pay rent in June, or did she actually pay the June rent and just didn't pay the additional amount towards the arrears, or did she not pay in June?
Didn't pay anything.
Okay.
I think is the.
All right, Mr. Kiernan, I'll give you just one last minute.
Okay, and I would note that in Exhibit 1 to the declaration, it shows that she had $916 withheld that 1 month, and that she would have $0 withheld every subsequent month. So they knew that she would be receiving months in the future. My client is also here. She has also been attempting to make ongoing payments to the landlord as it goes in good faith, because she wants to continue to maintain residing in the unit. The landlord had full knowledge that they would, if they looked at the paperwork and engaged in the process with Ms. Wiswin, they would have had full knowledge that she would receive the same amount. They withhold $916. Mr. McCreary is saying that as a result of my client's financial irresponsibility, she was unable to pay. This shows just no regard for how the realities of living on a fixed income, Your Honor. It's simply hard to budget when you're getting, $1,054 a month and you need to have living supplies. My client was not represented by counsel, and she made a good faith effort. I mean, she failed to pay rent because she was having a roach infestation. Was this the correct course of? But she thought that she was doing it to bring attention to the landlord's failure to maintain correct pest controls. If she was represented by counsel, she probably would have done this a little differently. But the idea that this rent failure was a result of her willful, failure to do that is just not true, Your Honor.
All right, thank you. I've heard enough. So in this matter, when I look at and again, I looked at everyone's documents and all the materials that were submitted by both sides. I appreciate both counsel. You've both made very good arguments for your clients. There is a substantial arrears given the fairly low rent that's imposed in this case. There's an admitted withholding of rent, as Mr. Kiernan points out, not correctly.
Thanks, guys.
But if she had withheld it and kept it, then it would have been available to her to pay later, and that clearly did not happen. The landlord, I don't think, is expected to have a crystal ball. At this point, they have a substantial period of non-payment. The best predictor of future behavior is past behavior, and I think that that's reasonable for the landlord to assume. At some point, they have to move on. They did bargain in good faith. They went through the ERPP process. They created a agreeable payment plan for everyone, and then it's immediately breached. And again, I think that the landlord doesn't have to accommodate just a non-payment. I don't think that's a reasonable accommodation to just not pay anything. It'd be one thing if we were moving a smaller payment or something of that nature, but at some point there has to be the ability of the parties to sort of go their separate ways, and that's what this process is for. So given that, I am going to issue the writ in this case.
Your Honor, Miss Wynn is getting a heart surgery next Friday. I would ask that next Monday, I would ask that we extend the writ in 30 days in order to accommodate that.
What is the nature, if you know, of the surgery?
I believe she's getting I believe she's getting she's on disability. I believe it involves her stent. I can provide later documentation to the court if we could do that. And maybe Mr. McCreary could simply agree to extend the writ. If we get a doctor's note, given the fact that there is, heart surgery happening on Monday, I don't think that she's going to be able to leave the apartment within 2 weeks. I think that's unreasonable.
Welcome.
And if I may, I guess there's only a little bit of experience that I have with that, since my father has been through a quad bypass and several stents and angiograms and so forth. I mean, if the nature of the surgery is
all right, I don't see, now I know what everyone's talking about. I don't see gifted memberships in StreamYard. And I hear all the other YouTube creators saying that. So now I actually get it. I saw someone say thank you or congrats to the new members, so I saw it. But Lisa, was it Lisa? I just swapped over. Yep, Lisa, thank you. Thank you for the 5 gifted memberships. I appreciate it.
Thank
What's
you.
that? No, you're saying
Lisa B.
Lisa B. Cooling with Colin. Oh yeah. I want to tell you guys a story about where my name came from. We'll finish this real quick.
Oh
But
yeah.
But yeah, I'll tell you. Here we go.
Just a stent removal. They usually do that orthoscopically, and it's a day procedure. I guess
we can work out with Mr. Mercury, and I'll file a motion to stay the writ if I have medical documentation or and such. If it's not to your satisfaction, Mr. Mercury.
Sure. No, I'll certainly look at it. I have some capability to understand those heart surgeries from experience.
Okay, thank you. And then also, given the nature of, again, I don't believe this is Will Fable, I would ask for an order of limited dissemination in this matter as well.
Mr. McCreary.
I don't generally object to those.
So court will sign an order of limited dissemination. I'd ask you just both sign that, and you can send it in ex parte at any time. What I'm going to do on the writ, a stay may be reasonable. There just isn't sufficient information before the court to make that determination. I'd ask the two of you talk, ideally come up with a good faith basis so you can both avoid coming back here. I'll sign the writ as is, but would you both like me to put you on next week to review that issue? Or do you think you can work it out?
I think we can work it out.
I think we can probably work it out. Like I said, I don't really know the severity of the medical issue either, so I don't want to do too much arguing, quite frankly.
Well, and my writs, I always have an extra, I think, 20 days on them, so we can do this with the sheriff's department.
Okay, yeah, that works for me, and I'll let you know. And I think there's 2 weeks on a non-pay anyways, so we got a little bit of a cushion anyways.
Okay, very good.
We got more DeSanto. I just saw someone say, yeah, here we go. The Stone is turning to stronger. Stone wasn't the defendant, or is it a defendant in that kind of case? Yeah, I think it is. I think it's still a plaintiff and defendant. But the defendant actually was on camera at the beginning and then got off camera at the end. So that Stone, that woman with the last name Stone, she was not the person that they were talking about. Welcome, people in court.
Hey.
Thanks for
that was kind of messed up.
Yeah,
I'm not really sure. I don't know how I feel about that. Like, not necessarily the decision of the case so much as that the social can't talk. The social security, the SS office.
It'll be fine.
I did. That they would do that. Like in the beginning, what they said was, I think they were overpaying her, like slightly, like you were saying, like a bunch, and then they caught it, and then they, instead of like taking it out gradually, like they put it in gradually, they just withheld an entire check. So she had nothing for a month.
I don't think
right. That's
what
he led me to believe, right?
I think she. I feel like they said numbers earlier. No, maybe they were just talking about rent. Yeah, I don't know how that works. I really don't know how that works.
I mean, I guess if the government's giving you money, they're going to screw it up. I don't know. They don't give me anything.
Yeah, I don't know. I'll tell you, my mom was on Social Security, and there were months where she got like triple what she was supposed to.
Really?
And she would call instantly. Yeah, she would call instantly. And they would always say like, "Oh, you're something about medical, like your medical was refunded." And she's like, all right, but I called, right?" Oh.
Right. Yeah.
Look who's here. Look who's here.
Who's here? Oh, I gotta look.
Hi. I have so much to say and I have so many questions, but I don't want to interrupt because I know that live I don't want to keep people here forever.
Like people like me or like other people?
Like everybody. I don't know. I don't want to keep the stream going forever, but okay. So, and Sylvia can probably attest to this because she obviously lives here in Nova Scotia, but during COVID, and I don't know what it's like in the States, but during COVID, our government issued called it CERB, which was assistance during lockdown. And they issued an extra basically $2,000 to everyone at the beginning and then said, oops, shit, we're sorry. We sent you guys too much money. We need everyone to pay it back right now. So is this a similar situation where it's like they gave her too much money and then she had to pay it back to them, or did they just take it from her? Like, I'm confused.
I think they just didn't give her her next check.
Yeah.
They're
So
just like, oh, we paid you too much, so sorry about this month. Just like survive on nothing.
Yeah.
Like,
it was
okay.
Which I don't think that's how it works. I really don't. I think they would take like a portion of it. So if
that's
she
what
was
I would
getting
think too.
if she was getting $1,000 a month, if she's supposed to get $1,000 a month, and then for like 3 months, for whatever reason, she got $1,500 a month, and just didn't tell anybody, and then so all of a sudden the government figures that out, like, well, we're going to take out $400 from each of your checks until that money's paid back. So instead of living on $1,000 a month, you're living on $600 a month. So that's kind of how I think it works. But again, I'm a YouTube undergrad law scholar, so.
Okay, so again, back to life here. Like, Nova Scotia has a ridiculous housing crisis right now. We have lots of homeless people living in tents, like in parks and stuff. And a lot of people like to blame government, disability. And I'm not saying I don't know people's situations. I'm not judging anybody for their life situations. But like the COVID CERB that we received, that because I lost my job. I didn't lose my job. My industry was shut down, so I couldn't work for 3 months. When you're given money and it's a surplus and you're like, oh, I'm not supposed to have this extra money, why wouldn't you either A, save the money because you know you're not supposed to have it, or B, call somebody and say, hey, you guys sent me too much money. Now, because she's not prepared financially, which is her own doing, it's now on her landlord to take the hit for her and be like, yeah, sure, no problem. It's a point the blame instead of her owning the fact that she didn't manage her money properly. Like, it's not the landlord's issue. So did they just did they just say, yeah, sure, no problem, you don't have to pay rent? Like, I missed the end.
No, she got kicked out.
Oh, she got kicked out.
Yeah. So her defense attorney was really good, and he made this giant story up. Yeah, he made this giant story to make you feel bad for her, and but the reality is she wasn't paying, and it doesn't matter how good your story is, but if you're not paying, you're already on a payment plan to pay back rent, and you miss a payment. There's nothing. It doesn't matter. You could have the best attorney in the world. It wouldn't help. And also the attorney for the landlord was amazing as well. So, but
yeah, the dude did a good job arguing for her, but at the end of the day, she didn't pay her rent. Like, sorry, too bad, so sad. Okay, I'm sorry for your situation, but
yeah.
If the defendant didn't have an attorney, that whole case would have been 30 seconds. She would have came up and said, "Oh, I'm on disability. I couldn't do it. I'm trying to pay it back." I'm like, "Sorry, bye." But the defense attorney for her did a really good job. So that's what made is like, eh.
So is this a common thing? Does this happen all the time? Like, is this a common case that you guys see on these court things?
Landlord tenant matters are common.
What is that, Christina? What's her last name? The Christina judge. I used to watch hers. I feel like it was back when the weather was cold, but she'd have like once she had like 300 or 400 like in a day. It was insane. Okay, maybe it wasn't 300 or 400. Okay, I might be exaggerating.
Yeah, there's a lot.
Okay, but she had a lot.
But I mean, it was like no, it was a number that made me like, wait, what? And I like rewound it and had to listen again. I don't remember what it was, but it was like a whole like off-topic conversation at the end, like just talking about how it was like, I want to say it was like 40 or 50 more than like she would normally had. It was like, I don't remember if it was like after a storm plus like stuff being backed up. I don't know. But it was just like, there was no way they're going to get everybody done. They had to like cut some people back. And it was, I mean, the amount of people they just had was insane. It's like, you got to go. It's because of that thing that is they're always talking about in Michigan that everybody applies for, and basically just everybody, 90% of people just like stopped paying their rent and like applied for this whatever it was. You know what I'm talking about? I can't think of what it is.
You're talking about the programs in Michigan.
Yeah.
I don't remember what they were called. There's two of them though, but the money ran out and people kept applying for them.
Yeah, and
All
then
right.
and then there were okay, sorry, go.
No, I want to show one last clip because Peach is
Mhm.
going live to 8:30, and I've
Yeah,
been
you're
on
right,
live.
you're right,
I've been live for an hour and a half, and I still have
Sorry,
like
Peach.
another hour worth of content because I keep pausing it. And she scheduled hers, and I don't want to butt into hers. So the rest of the content, I'll either make a premiere or do another live with. But
Just do
I
another
want to
live.
show.
Just
I
do
want to
another live.
show. Well, I also need to make content, but yeah, I want to show this
Yeah, I know,
video.
I do too.
This is my last video, and then I'm going to try to figure out how to send you to Peach's channel. But
She has to enable it on her end.
Oh, does she?
FYI. And I don't know how to do it to even enable it on my end, but I can figure it out and like help you guys figure it out. I have somebody who will teach me.
Oh, Jonathan wants to know the story of my name. All right, maybe we'll just do that, and then we'll play this, and then we'll just all go over there. Peach,
Yeah.
drop your link. Some like just mods, people keep dropping Peach's link. I'm gonna tell you the
Pin
quick
it. You
story
can
of my
pin
name.
it. Click on her name in YouTube on your phone or something, and then it'll give you click and hold it, and it'll give you the option to pin the chat, and it'll pin it at the top.
All right, when
Figure it out while you like play
the link's added.
Okay, sorry.
Yeah, I pulled it. Well, if I knew shiz, if I knew the link, I would just post it. It takes me.
I'll
it takes
post
me a
it.
minute
I'll
to find
post it. Tell the
Okay.
story. I'll post it. I'll
All
send
right.
it to you.
So my name, yeah. Now I'm frantic. So my name, hi Colin. Hi Lisa. Jesus, I just saw Lisa and I saw great to see you, Colin. I said hi, Colin. All right, Colin definitely not Cromwell. Came from it actually came from Irish Demon's channel, who you guys met earlier. When I first started on YouTube, I actually had my first and last name as my YouTube name. So I just started talking and started watching people's channels. So I didn't care if I was doxing myself because I was nobody. And okay, there we go. Someone posted it. Why?
You're
All right,
always
there.
somebody to someone.
Yep. I just got to figure out how to pin this. But yeah, I'm always someone to someone. That's nice. What did I do? All right. Trying to pin this. I can't. Apparently I'm not a multitasker. It's not. There we go. Pin message. There we go. Did it work? All right.
Probably, I'm not looking.
So it was my first and last name was my username. And I became a member of Irish Demons, and I was super shouting a little bit. And he was calling me Colin Cromwell. That was what he was calling me for a couple weeks until somebody said, hey, just so you know, that's not his name. You're mispronouncing his name. His name is not Cromwell. So he started calling me Colin, definitely not Cromwell, for a couple weeks. And then I just said, you know what? I'm going to change my name to that just because I think it's funny. And it stuck. So that's my name. That's where it came from.
You got to say who that is. I didn't know. Does everybody? Am I the only one who had no idea who that was?
The Cromwell. I don't know. I don't know the history. It's some guy.
Somebody does. There's got to be some nerds in the chat that know.
Yeah, some English. I think he was English. I don't know. Some really bad guy that the Irish hate, whose last name was Cromwell. You know what? That's the short version of it. But I want to play this video because this is a great way to finish and a way to creep you guys out at the same time. And then we're going to Peach's channel.
Yeah, there'll be a countdown first, so it's okay if it's like a minute or so.
Okay.
Yeah.
Well, so let me see now. What's your name, ma'am?
Yeah, but let's Jake Sears.
Sears is your last name?
Yes.
Like the store?
Like the store that went bankrupt.
Yeah, they did go bankrupt, didn't they?
Yes.
I got a funny Sears story, but if I
many
tell you,
others.
everybody's going to get angry at me because it'll take time. So you're charged
what do we think about
with
her?
trespass on property after warning.
That hair.
Yeah, they never gave me a slip. So I didn't think it was people warning. It was a different one.
Okay.
So I don't
Did you just move the microphone away so that he can't hear what
That's
she's
not the
saying?
most serious thing
Yeah.
to hear about. 'Cause
I guess there's not a mute button on it, and she can't shut her up.
you are trespassed from that
Good move.
location. So apparently, if you're going to use your account,
That
you
can't
have to
be her
do it
real hair.
online.
I can't go to any of them.
Do you know what
They would have taken it away if
online
it wasn't.
means?
No,
Yeah,
I
yeah.
don't have that access.
Okay. Well, you'll have to go to another location because I think you're only trespassed from that one store.
You know what I see when I
Okay.
look at this?
But I don't know for sure.
I
You
see
need to check
Cousin
that
Ed and
out,
Wednesday.
okay?
All right.
And you're also charged with battery on
Reminds
a
me of those
law
I'm
enforcement
with no
officer.
and no. She's the gingerbread house lady.
She is the gingerbread house lady.
Okay.
I started laughing.
And then
Just
you're
looks like
also
the gingerbread
charged with
house.
resisting with violence. So
But the voice goes
those
with
are
it.
some pretty
She's
serious
a witch.
charges. Let's do this.
Hansel and Gretel, that woman, the candy house.
Trespass
Yeah.
on property after, and by the way, you do qualify for the public defender. So I'll appoint them to represent you in the case. The trespass on property after warning, we'll set that bond at $100. The battery on a law enforcement officer, that's really the big one right there. But what I'll do is I'll set a bond on that one at $150. And then you got resisting with violence. I'll stay that bond at $1,000. So you can't go back to that store, right?
No, I talked to him coming in, and I said, you better let me know which one I can go to. If I can't go to
She's a
anyone,
witch.
I'll cancel
Burn
the
her.
account.
Okay.
He said he'd let me know.
Well,
The same office.
yeah. If you have anything else you want to say or questions,
No, not at all.
you want to talk to your attorney right there, okay?
God, if my hair had that much volume, like ever.
I don't have any.
Right?
She's probably got her neck muscles are probably.
No one knows she probably
They would have
smells like
taken it away,
sage
though.
and frogs.
Yeah. I mean, if we're lucky, but like they would have taken it away if it wasn't her real hair, right?
They would have, yes. When
That's
she
what I thought.
walks,
Okay.
Look at her hair when she walks away. Looks like there's
Okay.
cobwebs.
Oh God, they're probably. Oh God, I wouldn't have wanted to check it either. Oh jeez.
They probably did. Just
Oh
like,
my
no, we're not
God.
touching that.
You're welcome. Good
Oh
luck.
gosh. Oh my gosh.
Oh my gosh, what is on her
Real
head?
hair.
They keep talking about her now.
Jeez.
You were saying earlier, is that her real hair? That's actually her hair.
Is that her who? No,
It's-
oh, we're on the record. It's a very eccentric hairdo she has, Your Honor.
It's a tiny bit noticeable.
Yeah, you have to really like. Well,
It shocked me for a few seconds. I didn't know what to say.
Oh my
I was
God.
determined not to say anything because, whatever I said, it was going to be wrong. So
I like that, Judge.
Yeah, he's good. All right, because Heather worked so hard on my outro, I'm gonna play it. But
Yeah.
but everybody
Didn't
go
really work that hard on
to.
it.
I don't. We're probably gonna have to watch the last minute of this.
I'm done.
But
Well,
everybody
okay,
head over to Georgia Beach. Wow.
Good.